Hey everyone, Kelly Henderson coming to you again with another video on bond. So in the first video we talked about someone you know, you love, has just been arrested, they're in jail. What's gonna happen? Do they have a bond? If they don't have a bond, when are the opportunities for them to get a bond? We discussed the first appearance, we discussed the preliminary hearing. We discussed hiring a lawyer and what the lawyer could do at various points of this timeline when they've just been arrested. Another thing a lawyer can do as soon as you hire them with regard to bond is get on the phone with the prosecuting attorney's office, the district attorney's office. Most likely, it's usually only someone with a felony who's not going to have a bond assigned to them immediately after they show up, or certainly after the first appearance. The attorney can get in touch with the district attorney's office, figure out who the ADA is that's assigned to the case, and begin negotiating a bond with them. Now, if those negotiations aren't fruitful, then the attorney can file a motion for a bond. The attorney can also see if there's a 90-day bond available once the motion for a bond is set. So right now we're talking about more serious felonies like murder, okay? When you go to a preliminary hearing, the magistrate court, which handles preliminary hearings, they don't have the authority to set a bond for murder in most cases. So sometimes they can be given authority by a particular county, by a superior court judge. And also at a preliminary hearing, you can always do a consent bond with the assistant district attorney's office or the assistant district attorney assigned to the case. But that's not something that you could probably expect in a murder case or another higher level kind of case, that they're going to consent to a bond once for charges that high. So you need to file a motion for a bond in superior court and file a rule nisi to get a court date. And then two things. One, you can be still continuing to negotiate with the district attorney's office for a bond and preparing for your bond hearing. Also be on the lookout for how many days have passed. So on these higher level felonies where you're most likely to not have a bond be assigned at the jail or at a preliminary hearing, and you're still having this ongoing bond issue, well, there's a statute that says after 90 days, if a person's not indicted, then they have to get a bond. And indicting somebody, that's a function that the district attorney's office is responsible for. You've heard about a grand jury. That's when they take cases to a grand jury, and a grand jury is very similar to a jury in a trial. It's people from the community. They're brought in, they're shown the evidence, although in a grand jury situation, they're only shown the evidence by one side. They're only shown the evidence by the state, by the prosecutor's office, by the police officers that were involved in the case. And they go in and they present what they expect the evidence to show to the members of the grand jury. And then the members of the grand jury, they're looking at a lot of cases while they're doing their function. They're looking at a whole bunch of cases that have been prepared for them, and they're just saying, yes, we think that this case needs to be indicted. The indictment is a stack of papers that just has the accusations and the alleged, some facts about the alleged crime in it, and then it gets signed off by the grand jury. And that's basically what the district attorney's office takes to a trial. If someone goes to trial, the judge reads off that indictment to the jury that's been selected to hear the case, and says, you're here to determine whether these charges and these facts, whether they occurred on this date in this place by this person as alleged in the indictment. That's what a jury does. But first, the district attorney's office has to have a grand jury sign off on the indictment. And if a district attorney's office has not done that for somebody within 90 days, then that person is guaranteed a bond if they don't have one already. So in this preliminary stage, when someone's just been arrested, they don't have a bond, even after the first appearance, even after the preliminary hearing, then this 90-day bond is something that you need to keep your eye on, and the attorney certainly needs to keep their eye on. And so the attorney would get hired, file a motion for bond. Let's say even if there is a bond that's given at the preliminary hearing, but it's too much money. It's something that the family and the friends can't get together for this person who's been arrested. So you file a motion for bond or a motion for bond modification seeking a reduction in the bond amount, and you get a court date and you go to court, and there's the 90-day issue. If it's been longer than 90 days and there's been no indictment, then you automatically get the judge to give you a number. Now, how high that number is and whether it's affordable, that's something you need to be prepared to argue about and present to the judge as to how much the family can afford and what's reasonable given the circumstances. But if you're just having a straight up bond hearing, there's been 90 days has not run, or there already is a bond but it's too high, then you have to be prepared to argue the statutory conditions for setting a bail by the judge. There's 4 of them. There's 4 things that the judge has to consider. Number 1 is the person a significant threat of committing another felony after they've gotten out. So, what's the person's criminal history like? Are they currently on probation for the same thing? The next one is, does the person pose a significant threat to people, to the community, or property? Again, there's a criminal history is going to play into this. The specific facts of the case is going to play into this. Is the victim of this case someone who's been the victim of a crime committed by this person in the past, or is this, is the person on probation for doing the same thing, for committing a burglary, and now they think that this person is a significant threat to the community or to property, and then the person would also potentially be a significant risk of committing, another felony. Another factor is the person at significant risk of fleeing. With is the person from out of state? Is the person from out of the country? Is the person facing serious crimes that anybody would be thinking about running and trying to escape, dealing with the crimes in court? The 4th factor is, does the person pose a significant risk of witness tampering or otherwise, obstructing justice? Is the person going to go out and, if the victim is a family member, try to tell the family member not to testify against him? Or is, the person going to go back to the scene of the crime and destroy evidence? The facts would be pretty important in trying to make a case. If the district attorney wanted to try to make a case that the person was going to pose a significant risk of tampering with witnesses. One of the situations where this comes up a lot is gang crimes. Is the leader of the gang going to go out and tell all the gang members to, especially if other gang members are witnesses that are against a gang leader or another gang associate, then there would be a fear that someone's going to go out and say, hey, this person is talking, this person needs to be dealt with, and that witness would be killed or seriously injured or intimidated not to come to court and testify. So those are the 4 factors that a court would consider when setting a bond when the 90-day issue has not run yet. Again, it is, will someone intimidate witnesses or obstruct justice? Is someone at risk of fleeing the jurisdiction? Is someone a significant risk of committing another felony while out on bond? And is someone a significant risk of being a threat of danger to a person, to the community, or to property? So those are the 4 statutory situations, or 4 statutory conditions that a court must decide are not the defendant is not a significant threat of creating any of those conditions for the court after being given a bond and released from jail. So that's it. That's our second video on someone's recently been arrested. They don't have a bond. What can you do? What should you expect? What do you think the lawyer should be paying attention to? If you have any questions, leave them in the comment sections, and I appreciate any of your feedback. Thank you so much.